with a never-ending love for theatre, a far-sighted decision maker, and also a Supreme Court judge.
You have views, and depending upon what the political leanings of that particular media group, you carry a particular story. Even if the main story contains the flesh and bones of the story, the headline will be such, cleverly placed, the headline itself may influence the people or the reader to think in a particular direction. If judges are to write judgments believing in certain stereotypes, your ultimate conclusion or a verdict could be terribly wrong. We don't need to carry our court battles into our personal relationship. Personal relationship should remain pleasant at all times. Why is the need for breaking our head over an issue that we had sort of argued in the court? We don't need to carry that out of the court. Let the judge suffer with whatever arguments you have made.
Now, so you've been part of the collegium system in the Supreme Court, and you've also had your own way of processing when you were as a Chief Justice. How do you ensure that a genuine candidate is picked from the lot, considering all the mudslinging that may happen?
Since that particular experiment which I did in Kerala has yielded good results, meaning thereby the crop of judges which came through that process are considered to be the best that could have been appointed in Kerala High Court, I see no reason why the Chief Justices of other High Courts should not follow a similar system.
With a never-ending love for theatre, a trivia buff, a far-sighted decision maker, a favourite of the bar, and a pioneer of court humour in recent times. These are the few ways in which the Supreme Court Judge, Justice Hrishikesh Roy, has been described. Dear viewers, I'm Anmol Bawa, and you're watching a special segment of Livelaw where we get to know more about Justice Roy. Justice Roy was elevated to the Guwahati High Court in 2006 after practicing for 20 years. He was then appointed as the Chief Justice of the Kerala High Court in 2018 and then came to the Supreme Court in 2019. He recently retired on 31st January 2025. Sir comes from a family of non-lawyers, and he went on to become the first-generation lawyer and also a Supreme Court judge. Welcome, sir, and thank you so much for taking out time for us.
No, I'm very happy that Livelaw is here for this conversation, and I'm looking forward.
So, going back to your childhood, you have openly spoken about how in the childhood you were very clear that you want to take law. And you also are a very multi-talented person. You were interested in theatre, books, music, writing. But what was that one factor that compelled you towards taking law as a serious career?
You see, the time when I decided to take up law as a career, I don't think my senses were so well developed that I can give a very clear answer to your question as to what prompted you to take up law. But I would, if I think back, as a 9-year or 10-year-old child, when the thought was born, I used to sort of join in the local meetings where children are encouraged to speak. So very often I would be speaking in meetings where whatever the topic is, and people used to say that he speaks well. Of course, all this was in Assamese language. And and then lawyers, you associate them with the communication world. So maybe that's how the thought, sort of got planted in my mind. But I was very sure from childhood that I will become a lawyer. And a lot of my friends of those times, I mean, who must have been 10, 11, 12 years old, have written in my autograph book that, Hrishikesh, we hope you become a good lawyer. And you mentioned, very happily, you have sort of touched on a favorite thing of mine about reading books and also theatre. I have a great love for books right from my childhood. And that was also the custom in our family. My father, Kishori Mohan Roy, was an engineer, but he was an avid reader. Sportsman. My mother also reads a lot. So therefore, the culture of reading was very much in our home. And somehow theatre also permeated our home in some way, because one of my brother, he's a product of the National School of Drama and also the Film Institute, student of Ibrahim Alkaji, the first director.
Wow.
So there's a culture of theatre amongst the family members. For instance, right now the National School of Drama Festival is going on. And yesterday I was at the Kamani Auditorium with my wife Chandana watching Ajat Satru, the Ibsen's classic, The Enemy of the People. We enjoyed that yesterday evening.
And this was which genre?
The genre is basically environmental concern. A very, one should say, somebody who is concerned, a local doctor is very concerned about the pollution in the lake. But the others, they're thinking about the commercial outflow from those who will be visiting the lake on a particular auspicious day and maybe taking a dip in the lake. So if he sort of spreads the word that the lake water is polluted, then this particular auspicious day, there will not be that rush of tourists and that commercial interest will be affected. So the play is about the people who are commercially inclined and a person who is trying to warn the people that, look, the lake water is polluted, so don't go for your pilgrimage there because you might fall sick or you might sort of die also. So it is cross-current, brilliantly directed by the celebrated director K.K. Raina and part of the ongoing theatre festival in Delhi.
All right, viewers, we have one recommendation from Sir already. So, talking about your love for theatre, talking about your love for the performing arts, you have also directed a play during your college times. You do love watching plays, and we have also heard that you love to take your interns and law clerks also for such creative events. There's clearly a penchant for creative expression that you have. So my question is that how do you think art and the theatre, the performance arts in particular, influence or mirror the socio-legal issues of our society?
Anmol, I would suggest that great authors, great playwrights have written plays which actually reflects the society's happenings. The writings, great writings also warn us of what might have to be, we have to be cautious about. And it also shows in certain ways the directions or the way forward. Now, when you talk about the creative part is the creative people are actually in the forefront. The poets are in the forefront. The authors are in the forefront to say what is wrong with society and what needs to be done. I do not know whether any of your viewers are familiar with plays like, let us say, Taj Mahal Ka Tender. It's again a very rollicking play where they talk about how a tender was floated for construction of somebody who dreamed something like a Taj Mahal, and how the entire process got mired in bureaucratic red tapeism, and also the corruptions and the other things which are involved. And we also have a very interesting thing which relates to the drama in court. For instance, things like 12 Angry Men. That's a theatre on trial of the 12 jury members, and they were conducting a trial. And the Hindi version is Ek Ruka Hua Faisla. I would recommend Ruka Hua Faisla to anybody who is interested in either law or in theatre. Then similarly, Witness for the Prosecution. That's another play that or a movie that I would recommend anybody who is interested in law or in theatre. So there are many this thing, but when you talk about how to relate theatre to court activities, in fact, recently I had an occasion to give a lecture to the lawyers of the Bar Association of India. And there, of course, many eminent lawyers were there, and they were being awarded. 5 lawyers were awarded, and I was incidentally requested to be in that event. When I compared the work that a lawyer does, for instance, if a lawyer prepares his briefs, the notes to be argued on the next day in the court, so he's actually preparing his script for the next day's play. The court is actually a stage where the judge is presiding over it and the lawyer is performing. The assisting lawyers to the lawyer, and you have many lawyers here who you always interact on a daily basis, they are the prompters who are helping this lead lawyer to sort of say his dialogues well. And then you also have a character like a Vidushak-like character who could be the amicus in a matter. And the judge, if you want to give him a little bit of credit, he might be the person who brings up the curtain and brings down the curtain in a matter, so to say.
So there's a follow-up question to this. You mentioned about how the courtroom itself becomes a stage of sorts.
Yes.
So when we talk about films,
Yes.
and when we talk about films on law, films on the legal issues that we see nowadays in the mainstream, to what extent, you being a judge yourself, do you think that films today have correctly understood the correct portrayal of the courtroom, or there's still a long way for them to understand and appropriately depict courtroom drama per se?
You see, the films, they also have to generate revenue. So very often they bring in certain elements which may appeal and bring the viewers to the theater hall. So they try to have, for instance, a lawyer in a courtroom drama will wear a gown, but you might find his band in an awkward way, meaning thereby a lawyer will not put the band in that particular fashion. But if they have a lawyer who is advising them on how the courtroom should be constructed, or how a lawyer should be dressed, or how a judge should be dressed, perhaps these technical small details can be taken care of. Otherwise, court proceedings are usually very dull proceedings. And if you have to plant a film, you are not going to get many audiences if you are going to present a dull item. So therefore, to make the what is conceived as a creative thing to be an interesting one, they will, of course, borrow things from real life court situations. For instance, there was this film called The Jolly LLB. So there they have a very ongoing and a famous dialogue of Tariq pe Tariq.
That's also in Damini.
That's also in Damini, right? So these are concepts which very often people sort of relate to the situation in court. Somebody who is going day in and day out, or month after month going to the court, seeing no end to the trial. So therefore, they borrow certain things which are commonly ingrained in people's mind, but they put a bit of a spice, a bit of a tikha, a bit of a meetha in order to make it attractive for the viewers.
So, talking about films, you are the only Supreme Court judge to have also been a producer of a film, 2 films, that is Apne Ajnabi and the
Shako,
Shako.
The bridge. Yeah.
Yes, Shako. Now, your Apne Ajnabi was based on racial prejudice,
Yes.
per se. What is your take on, society's perception towards caste and race, and has it improved in any way today?
You see, this particular film, Apne Ajnabi, I did it when I was associated with the Arunachal Pradesh Legal Service Authority. Now, when I was speaking to the people from Arunachal, because that was the time when I had maximum association with people from Arunachal, I realized that many of them, they come to Delhi, for instance, for higher studies, either in college or for higher studies, postgraduate studies. And particularly when they're finding out rental accommodation, or they might be cooking something which might smell a bit. So the landlords will have issues with these tenants, and then they will either taunt them, or they will ask them to vacate the premises. So these prejudices were very, very commonly experienced by people coming from the Northeast who have, let us say, features which may, would be something like the Chinese might have. So they are very often called the Chinkies. So therefore, I thought that we had a little bit of budget to communicate. Of course, we can't be doing a film for the purpose of court-related work. So we thought that if we can bring in how legal aid the project Legal Aid can be projected through a film, and we took up the film idea Apne Ajnabi, and we arranged for it to be done in a professional fashion. I have my few friends in the National School of Drama, so I arranged for the script to be prepared in a professional way, and we arranged for the shooting to be done in a professional fashion. The actors were also selected on their capabilities, not because they are good lawyers or not like that, but because of their histrionic talents of acting and their capability to deliver the lines well. And we had this Apne Ajnabi on behalf of the Arunachal Pradesh Legal Service Authority, but basically to convey the message of legal aid being available. Here was a character who was suffering prejudice in Delhi and was feeling hopeless. And then somebody suggested that you approach the Legal Service Authority and a legal aid panel, how he was able to assist this particular victim of racial prejudice was the theme of the story. But the underlying story is legal aid for available through our system.
So, to what extent do you think that judges are immune from such parochial notions of racial discrimination, such parochial notions, thoughts?
Judges, I think, particularly higher judiciary level, I don't think there is any prejudice as such. I don't think so. Because we have judges from all sorts of backgrounds, including reserve category. I don't think there is any racial element in their functioning or they feel any prejudice. And suppose, for instance, you are a judge from Northeast, so you are in your own setting. So therefore, I don't think there is any such issue so far as judges are concerned. We are talking about people who are on the streets, who are it's not that judges are not on the streets, so we go for our experiences outside, and so therefore the judges are also on the street, but still not like that you are bussing it or you are waiting for an auto rickshaw. Those things are rare experiences. I hope to experience them now more. And so that's how I feel that at the ground level, they could succumb to such prejudices, but not judges. I don't think so.
So, given a chance that if you had to produce a new film now that you do have time, what would be that one theme, social legal theme, apart from racial prejudice, that you would pick up for the contemporary cinema?
See, in court and in judiciary, we are trying to think of ways where we make our judiciary more effective. And how do you also deal with the caseload, for instance? It's a huge caseload. I was thinking, and that is how now let me talk about the other film which I produced, which was The Bridge, or in Assamese it is Shako. That was about mediation. How mediation can be a very effective means of alternate dispute resolution mechanism. So there again, we picked up a story of two siblings fighting for their ancestral property, going to court, suffering a whole lot of difficulties and loss of money, loss of income, and of course, the loss of siblings' love as well. There we brought in the mediators, the judge coaxing the parties to go for mediation. And eventually, through the process of mediation, what was escalating into a never-ending battle of also of patience, if not other elements, was resolved amicably. And we thought that it conveyed a very strong message that instead of opting for the normal judicial proceedings, which might be never-ending on occasions, you can resolve your disputes through mediation. And when we take recourse to the alternate dispute resolution mechanism, so I was also thinking that could there be a film on, let us say, arbitration. Now, we always talk about arbitration, but giving dry lectures on arbitration and projecting arbitration to a film situation, I think it will communicate the message in a much stronger way. So if you think that what could future be done, I think something on arbitration can be an option.
I'll look forward to that.
It may not happen for me because these things, yes, it needs a team effort. But otherwise, I'm not involved in a creative field right now, actively, that is.
So, in your farewell speech, you mentioned that while your time at the Guwahati High Court as a lawyer, you worked as a legal correspondent, also a legal journalist with the Assam Tribune and the Press Trust of India.
Yes.
What can you share your experience as a legal journalist back then?
I was a legal journalist by accident. I think all of you have come here by choice. You are a very important figure in legal journalism, I must say, Anmol. But so far as I was concerned, is at the time when I was practicing, a great part of those times, Assam was a disturbed area. Or rather, in fact, most of the states in Northeast were disturbed areas. Now, Guwahati was the High Court of 7 states. Now, of course, it is a High Court of 4 states, but those days, it was the High Court of Assam, Meghalaya, Manipur, Tripura, Arunachal Pradesh, Mizoram. So these 7 states, I hope, Manipur, 7 states are there. Now, each of them were a disturbed area. So there were a lot of activities which led to people having suffering, detention, people otherwise suffering some kind of torture. And very often these victims had no recourse to law. Now, there was a group of young, not only lawyers, but also others, who thought that if we can get them some legal aid, this category of people who had no recourse to any legal aid. And that time, legal aid was not a charming term as it is now. So I volunteered. So I used to do a fair number of pro bono matters in the High Court. Now, certain matters or certain persons were important enough for the journalist and the media to be interested in. So very often they used to come and have their briefings from me about what the case is all about, what the issues are, and all that. So I sort of became a familiar face for the media people. But they were not dedicated law reporting media. They used to come on a day when they knew a particularly important case is being listed. So when they sort of got used to this easy briefing from me about the day's event or the day's case, then the Assam Tribune group, to begin with, they said that, would you do the coverage formally for us? So I said that, look, I can't be doing it full time and I might miss out a few things because my first thing is the profession. So besides that, I'll keep my eyes and ears open, and if anything is of importance, I'm sure I'll get an inkling of that and you will get a report. So Assam Tribune was the first one. And then the Press Trust of India also came. So they also entrusted me their legal reporting responsibilities. And so this I used to do. And as you know, if whatever you have reported gets published in the newspaper next day, or PTI carries it and then it gets carried in national newspapers, you feel good about it. But one thing which led to my being associated with these two print newspaper was the Guwahati Doordarshan asking me to do a couple of stories on law, which I of course found terribly boring. I did find them very interesting, but then I had two very fine experiences out of those because once
you interviewed,
got
to interview
the story, right?
You got to interview a few dignitaries from the legal profession
from the legal field. Fali Nariman was there in Guwahati for an event. Similarly, Soli Sorabji was there for an event, and then Doordarshan firstly asked, because I was associated with the organizing the event. So they firstly asked that would they be willing to face the interviewer from the Guwahati Doordarshan. So when they said yes, when Fali said yes, then Doordarshan after a few hours reverted back to me that would you do the interview for us? So I was a little puzzled, that I was skeptical also whether I could ever do the job of an interviewer, but then they felt that they don't really have anybody else. So I was, let us say, a last resort kind of a thing. Out of sheer desperation. But I enjoyed that conversation. In fact, I have taken a few things out of that conversation in my legal journey as well. So although both men have passed away, Fali Nariman and Suri Sorabji, but a bit of my growth as a lawyer, I would attribute to these two gentlemen whom I interviewed on behalf of Guwahati Doordarshan.
So, since you have experienced legal journalism in those days, how do you see is the today's legal journalism, the branch, how has it evolved any differently? What major changes do you see in the previous year's legal journalism and the journalism in law today?
Well, this might apply to journalism across all genre, not necessarily law-related issues, but I do have a distinct feeling that earlier, if a report is published in a newspaper, those days it was not the days of visual media. If a report is published in a newspaper, you will know that this is the raw bones and the blood of the story. But now, instead of news, very often, particularly in TV debates, you get views. Views of either those who are participating in that TV debate or who are the anchors of that particular TV debate. And very often the print media also, of course, I don't put everybody in the same category. There are certainly honorable exceptions who does news as news should be. You have views, and depending upon what the political leanings of that particular media group or what your compulsions are of that political media group, you carry a particular story. Even if the main story is, let us say, contains the flesh and bones of the story, the headline will be such, and you know what the headline, a lot of people just read the headline and they end it. So headline will be in such a cleverly placed that people would think that although the rest of the story may be something else, but the headline itself may influence the people or the reader to think in a particular direction.
So, several of your decisions center around the issues of human rights and gender equality. For instance, in the 2023 five-judge bench decision in which you were a part on the simplifying the procedures for the passive euthanasia. That was one judgment that was on human rights. And most recently also gave an order regarding how people should not stereotype the trauma of a sexual assault survivor. That is to say that it may time and there may be various ways in which a sexual assault survivor may express, and it may not always be a hue and cry per se. Now, so when we talk about these beautiful judgments, we talk about these impactful directions that come from the apex court. Are these enough, or somewhere the society also has a key role to play in bringing these words in the judgment to life?
I think, Anmol, you have asked a very important question, because if judges are to write judgments believing in certain stereotypes, your ultimate conclusion or a verdict could be terribly wrong. Now, if somebody is being subjected to sexual assault, what were the circumstances at that particular point of time when the assault was taking place? What was the state of mind of the victim? Was she in a very vulnerable position because of other things which had happened just previous to the actual assault? Is she the kind of person who can retort back? Or is she otherwise a timid person by nature who, being confronted with a sexual assault situation, would not sort of retort because she's so fearful? So therefore, if you test the victim's thought process through stereotypes in your mind, you may get to a wrong conclusion. So that was the caution that I gave, that reaction of every victim in a given assault situation may be different. So a judge should be sensitive enough, particularly when the prosecutrix is being examined in court, to understand what could have been passing through her mind, what was her state of mind, what was the degree of vulnerability she felt at that particular point of time, these elements should come in the decision-making process. And the other thing the first question that you asked about, there, of course, you know that this nurse in a Mumbai hospital, her name was Aruna Shanbag, right? Aruna Shanbag. She was subjected to a brutal sexual assault in the basement of the hospital when she had finished her duty and was to go home, perhaps reaching out to her two-wheeler. And that time, one of the hospital employee, brutally assaulted her, and he wanted to actually strangulate her, which sort of, prevented her from breathing for multiple minutes.
She went into a vegetative state.
So went to a vegetative state, and her life was, there was no meaning to the life that she had thereafter. But the nurses in that hospital, they felt that she needs to be, looked after, cared for, although she is in a vegetative state. So the question was that whether the life support system that she had access to in the hospital, she was given one room exclusively, whether that should be turned off after so many years of this vegetative state, or she should continue to receive the life support system. So in that context, you have what is called the passive euthanasia, and whether this is a debate, it's an international debate. But the first time I got exposed to this debate was, again, I come back to a play called The Whose Life Is It Anyway? This was a British group who were performing, I think about 40 years back in the Kamani Auditorium, Delhi. One of the most brilliant plays that I have seen. This was the play where the protagonist is a sculptor, and he met with a road accident. And when he met with the road accident, his life was confined to life only above the neck, and rest of his body was in a vegetative state. So he was confined to a hospital bed. So he was thinking, what is this life that I have? I need to sort of go on and not preserve my life. Then the hospital orderly, who was a black man and who acted the role of the orderly, he had very interesting things to say to him. He said, "Man, you are feeling sorry for yourself and you can do so many things." So he said, "What do you mean? I am confined to my bed, I can't do anything, I can't move. Even my bowel movement has to be, is dependent on somebody bringing the bedpan and stuff." And then the orderly said that, "Look, you can do so many things." Then the patient said, "Tell me, give me an example." Then the patient, who is confined to the hospital bed, was told by the medical orderly, "Look, if you have an interest in sports, and I find that you take an interest in sports, you can be refereeing a tennis match." How? Like, you can sit on the chair and then you can move your head from left to right as the ball is moving. You can very comfortably umpire a tennis match. And on a particular day when you feel active, you can umpire a table tennis match also. He said, "In what fashion?" There you have to move your head quickly, so you can table tennis match, you can do it like this. So this was the lesson that I saw in Whose Life Is It Anyway? A very celebrated drama troupe from UK had come, and I had the opportunity to see that about 40 years back.
That's very interesting. Yes. I think all of us in our team would also go back and try seeing its snippets.
I think it could be available in YouTube. Whose Life Is It Anyway? Ek Ruka Hua Faisla, My Cousin Vinny, some of the films I recommend for all the viewers who might be watching this show.
So you've amply talked about the mounting pendency of cases in the judiciary, right from the apex court to the lower judiciary. What, according to you, would be a most practical way of tackling this issue?
You see, we already have systems in place. And the system is what? The alternate dispute redressal mechanism. Now, in that, what do we have? We have a conciliator, we have a mediator in mediation process, and we have an arbitrator or a panel of arbitrator in an arbitration process. But a conciliator or a mediator or an arbitrator, they cannot reduce the penalty of a person. meaning thereby somebody is sentenced to 10 years, they can't make it 7 years. Those tasks or to order acquittal of a criminal is essentially of the court and the judges in court. So therefore, if you allow the courts to deal with core matters where only judges can decide, like criminal matters, only judges can decide. It can't be decided by an arbitrator, it can't be decided by a mediator. So therefore, if we can transfer the disputes, which could be commercial disputes, domestic disputes, or disputes which need not receive the attention of a judge in a court, that is one of the ways that you can address the arrears in court. Otherwise, when we talk about increasing the number of judges, when we talk about increasing the number of courtrooms, it is not a simple thing to increase the number of judges, because along with the judges, you need the paraphernalias like the infrastructure, you need paraphernalias like the courtroom staff, a stenographer, and so many other things which for a judge to function effectively are needed. You need libraries. So, and also the fact that whether we have enough talented people to come into judiciary. Of course, now a lot of bright students of any discipline, they are opting to go for law, which was not the time when we commenced our study in law. But now I find increasingly the young bright students are opting for law as a career first choice, which was not the time, not the situation when we started. So therefore, if we have effective alternate dispute resolution mechanism functioning well to its optimum capability, perhaps some of the issues of addressing the arrears can be resolved. Increasing the number of judges, I'm a little skeptical because, as you know, Anmol, say in Allahabad High Court, we have sanction strength of 150. But we have never been able to fill up 150, the total number of vacancies available. Of course, there would be a bit of a retirement happening and some appointments being in the pipeline. But then we have vacancies, but we have not been able to. There is usually about 70% posts are filled up at the High Court level. About 30% vacancies are constantly seen and visible.
So talking about court vacancies, a related topic, that is the collegium system. You've been quite frequently asked about it, and in one of your replies, you've detailed how when you were the Chief Justice of the Kerala High Court, there was a certain system that you followed. You asked your fellow judges to shortlist certain names of the lawyers that they thought were competent. And then with those shortlisted names of the lawyers, you would personally assess them by listing their matters in the Chief's court and evaluating them. Now, sir, this may be one process. You also mentioned about aberrations and an aspect of jealousy that comes in these selection processes, and individuals may try to malign the other individual through various ways. Now, so you've been part of the collegium system in the Supreme Court, and you've also had your own way of processing when you were as a Chief Justice. How do you ensure that a genuine candidate is picked from the lot, considering all the mudslinging that may happen?
Anmol, you and your team seem to have done a serious research on me. So, but thank you for reminding me of the Kerala experiment. And since that particular experiment which I did in Kerala has yielded good results, meaning thereby the crop of judges which came through that process are considered to be the best that could have been appointed in Kerala High Court. I see no reason why the Chief Justices of other High Courts should not follow a similar system. That would certainly address the issue of nepotism or favoritism or even the jealousy factor that you have sort of highlighted. Eventually, your role as a member of the collegium or as somebody who is heading the collegium, which is, of course, the Chief Justice of India does it for the Supreme Court, and for the High Courts, it is the Chief Justice of the High Court. The prescription is that you can't become a Chief Justice in your own High Court. And the primary reason why such a rule is in existence, except for the thing when somebody has a very small duration, he can or she can become the Chief Justice in his parent High Court. The reason is that since the Chief Justice is an outsider, so far as a particular High Court affairs are concerned, he will be neutral. So he will be able to avoid the charge of nepotism, he will be able to avoid the charge of favoritism. So these things, these are the essential reasons why a Chief Justice is always deputed from, is not made a Chief Justice in his own parent High Court. That's why from Guwahati High Court, I had to move to Kerala High Court, and that is the experience of many of my brother and sister judges. Now, that is one element of ensuring that there is no nepotism. But to shortlist the best in a particular court, a Chief Justice, because he is holding court in courtroom number 1, the lawyers under that particular High Court, all of them may not be having matters in courtroom number 1, or the roster that the Chief Justice fixes for himself may be those rosters which are dealt with by, let us say, courtroom number 2 or courtroom number 3, meaning they are by the second senior most judge or the third senior most judge. So if the Chief Justice has a consultation with the other colleague judges, in that case he will have a better idea, and the selection that is to be made, or the stock from which selection is to be made, that will be more broad-based, and I think it will give a fair chance to somebody who may not be directly noticed by the Chief Justice or the senior judges.
Sir, recently the anti-constitutional remarks by the Allahabad High Court Judge, Justice Yadav, that has been very much in debate and discussion. And there have been quite similar remarks very often we hear from sitting judges or retired judges. Now, so what is your take on how do we address such issues where the public confidence is infringed in a way? What is your take on impeachment? Is definitely one way, but how would you like to address this?
You see, to speak on a specific issue, it may not be proper. But nevertheless, you have mentioned a particular instance of the Allahabad High Court judge. What happens is that we have, let us say, in the high courts, we have, let us say, 1,000 judges, functioning judges, 900 odd numbers, 1,000. Similarly, in Supreme Court, we have 32, 34 judges. We are finding instances of comments being made, which are, say, loose cannon comments or not very responsible comments. These you can't be attributing to these 1,000 or these 33, 34 judges. So by and large, the judges are following the norms they are expected to follow. You know the Bangalore principle. We have a certain behavioral standards prescribed for the judges, and most of us follow it. And those who don't follow, you can take it as people who have not got out of their skin which they had at the time when they were elevated. I can give an example of Justice Krishna Iyer, who was a minister in the communist government in Kerala. Then he became a judge. But once he became a judge, the color that he had as a political person, it simply was not visible in his judgments at all. He was one of those fierce upholder of freedom, one of those progressive judges who was a trailblazer in many ways. So therefore, when we take oath at the time when we get sworn in as judges to uphold the Constitution and the laws, if we remain true to our oath, I don't think these kind of aberrative behaviors can be noticed. And visibly, they are not noticed. There are one or two exceptions, which is what I think all of us are concerned with.
So, you've had a long career as a judge, and you've also amply talked about the issue of legal aid. And would you still say that the poor are still marginalized in some way, are still at a disadvantage when it comes to seeking justice from the system? And what is the most effective way to reaching out to the poor? Because very often they won't even be aware of the facilities available at the legal aid schemes.
The word that you have used is reaching out. I take that as the key word in your question. And that reminds me of a program when I was a judge in the Guwahati High Court, which we initiated, addressing this very group of marginalized people who were unaware of legal aid that might be available. But the program, since we are addressing largely Assamese-speaking people, so we named the program in Assamese Hohari. The word is Hohari, right? Now, to get an equivalent word for Hohari, because I, as a person whose mother tongue is Assamese, I can understand the meaning. Reaching out is naturally very close to Hohari, but nowhere close to Hohari for the complete meaning of Hohari. So I had to use two words in English. We say that English is a very strong word, strong language, and it can communicate and a lot of things. But for the word Hohari in Assamese, I had to use two words in English, reach out and respond. So as a judge of the Guwahati High Court, we initiated the Reach Out and Respond program. And that program, I feel gratified that with that program, we could reach out to a large number of marginalized people through the State Legal Service Authority, the Assam State Legal Service Authority, and the model was replicated at the district level and the taluka level through the District Legal Service Authority. So the program that I speak about is the Reach Out and Respond program, which was there in the Guwahati High Court. So that is one of the ways. So I think each person who is entrusted with responsibility for reaching out to the marginalized people who do not have access to justice, and not only justice, who do not have access to the various governmental schemes which are otherwise available, because they have to fill up a form, they have to get a certificate from a gazetted officer, they have to obtain some certificate from, say, district magistrate's office. Now, this our paralegal volunteers can do. In fact, there was this lady called Ilachi Devi, if I recollect correctly. She was in Lakhimpur district of Assam. And one day I saw in a newspaper the photograph of Ilachi Devi with her 3 orphan children. She was going out to look for some roots and vegetables because the children have not been fed for 2 days. They had not a single grain of rice in their home nor anything else to eat. So I was the head of the Legal Service Authority then, headed by, of course, the Chief Justice. I think it was perhaps just Chief Justice Ajit Singh then. So I requested the local district Legal Service Authority in charge judge to go and find out what is happening. So he reached Ilachi Devi's whatever hutmate or whatever you call it, where she was near a abandoned, I think, railway place. And then first thing, when he saw the plight of this lady and the 3 orphan children, he bought a bag full of rice for them with his own money, without waiting for any government help, etc. Then first thing is that arrange for a hot meal of rice, cooked rice, to be eaten by the family. And thereafter we followed up this particular case. The children, they were educated in government schools. As a widow, she was entitled to a widow pension from the Assam government. We arranged for her to apply and got that widow pension sanctioned for her. She was entitled for a house under the Prime Minister's Awas Yojana. A house was constructed for her. And, it was such a transformation. And within about 6 months or 1 year of this encounter of Ilachi Devi with the Legal Service Authority of Lakhimpur district, if I recollect correctly, her life had changed. We have had many such instances of, heartwarming stories which I can share with the viewers, but I thought that this story deserves a mention in a show of live law.
So we've also seen nowadays lawyers making unbelievable amounts of money, but there is only less when it comes to contributing towards the society, contributing their share towards the society. What is your take on this, the need for giving back to the society as lawyers?
I am quite sure that lawyers also do contribute, particularly when there are national calamities and stuff like that. In Kerala, as the Chief Justice, when the floods happened, I found lawyers, judges, everybody contributing whatever they could, financially and also physically. I found my colleague judges, including sister judges of Kerala High Court, sitting down on the floor of the High Court corridor, packing up the essential items, flood relief items to be delivered. I also saw the Supreme Court lawyers. That time, I think the president of the Supreme Court Bar Association was Dushwan Dave. And he had mentioned it, in fact, in the ceremonial bench that was the last bench of my last day sitting. The Assam in that particular year was devastated by flood. Flood is a recurring phenomena in Assam, but that particular was particularly devastating. I was associated with the either the legislative authority or anyway, I was still in Guwahati. So the Supreme Court Bar Association decided to contribute to the floods in Assam, and Dushwan Dave was the president. I still acknowledge that. About 40 lakh odd amount was collected here, and that was transmitted to Guwahati. The only thing that time that was asked for, I think Justice Ranjan Gogoi, the former Chief Justice, was there. He was not the Chief Justice then, but he was asked who should we route it through, and somehow he mentioned my name. So we arranged for the flood relief. Very often, in flood relief, what happens, it comes to the say, capital, and from there it gets dissipated. So the final relief may not reach the flood victim. So what I devised was, in Assam, that we identified, let us say, 12 very vulnerable spots, and we arranged for the flood relief materials purchased through donation from the Supreme Court bar members to reach those 12 spots and actually distribute. And I arranged for distribution through lawyers who volunteered their service, Guwahati High Court lawyers who volunteered their service. And what I did after the exercise was over, I got the entire our purchase, our distribution, everything audited, and I sent it to the Supreme Court Bar Association, so that all accounts are absolutely, in black and white and cleared. I think that's, although you might say that the lawyers, they don't, but I suppose they make so much money, perhaps they don't distribute as much. That could be one of the things that you might be highlighting. But that's an individual choice. But there are people, we have the example of the Attorney General, Mr. Venkatramani. He is very committed in various social causes. And I'm sure there are equally people who might be contributing, and a lot of people would anonymously contribute. I know a few, so I would not like to mention. So they don't want their names to be associated, because they feel that why you embarrass somebody by saying that the money has come from so and so. So they don't want to contribute, lending their name to the contribution, but they anonymously also contribute. I know a few very well-known, lawyers, and who earn well.
So this was a little more on the senior lawyers. Talking about the junior lawyers, I have this. My next question is in two parts. Firstly, recently we've seen discussions where the junior lawyers or the freshers are heavily underpaid. There have been stories where they're not even being given the cost for traveling, for running from one court to another. So what is your take on this? How can the system help in improving their situation? And the second is, along with this financial exploitation, so-called, there's also an issue of the ignorance of mental health, the need for having a balanced work condition environment, safer workspaces, both physically and emotionally. Where do you feel, how can you or the judiciary or the bar associations in a way address this issue?
This is a very important issue, particularly for the young lawyers. Now, there used to be chambers earlier, seniors, not chambers, seniors, who used to feel that if X is permitted to be a junior in that chamber, that itself is privilege enough, and he or she doesn't have to contribute to any earning from to the living upkeep needs of that particular junior. Now, for somebody who comes from a reasonably affluent background or who could afford those early days of financial struggle with support from the family, it would not matter too much. But for somebody who don't have that money, the initial expenses for his living or her living, and then so very often earlier the lawyers who used to enter the system, particularly in the litigation field, were from a reasonably affluent background. But now we are increasingly seeing lawyers who are coming not necessarily from a very affluent background. Now, there are 2-3 things that you might like to speak about. We have now the system of appointment of law clerks with the judges. The law clerks is a paid job. And I think if I am not too sure who sort of initiated that, but it was Chief Justice Ahmadi, I think, Chief Justice Ahmadi, who went for a trip abroad to America, and he saw the system of law clerks, and he thought that this needs to be replicated also in India. I think it was Justice Ahmadi who first mooted the idea of law clerks, and now each of the judges have the support of law clerks. Law clerks are paid. It doesn't matter which background they come from. So at least their immediate needs of, say, rental accommodation or their, nourishment, etc., is taken care of. The lawyers are also gradually realizing that this bright girl or boy has come to my chamber, but she may not have the necessary financial resources to sustain herself in a very expensive city like Delhi. So they are also providing, some kind of a financial support. But the exposure to a lawyer is a very essential, senior lawyer, and actually working in the chamber of a senior lawyer is an essential part of your development as a lawyer and your journey as a lawyer. Now, while again I was in Guwahati, I continue to revert back to my own experiences. Through the Bar Association of Guwahati, I mooted the idea that can we send some of the young, bright girls and boys to Delhi to be trained for, let us say, 3 months under a seasoned senior in the Supreme Court. I mean, not that they are coming here and permanently staying in the Supreme Court, but I thought getting exposed, as I have got exposed in my early days, to the practice and arguments in the Supreme Court, they would benefit. So we identified lawyers here, say Justice K.V. Vishwanathan, he's become a judge now. Mr. Giri was one such lawyer. So we identified some of the lawyers who volunteered that yes, if you select the girls and the boys from the Guwahati High Court, they can work in my office and I'll pay them enough so that they can either stay in a rented house or in some hostel and their food, etc. will be taken care of. So I did this experiment, but somehow I did not, could not carry it forward because I got transferred to Kerala High Court, as you know. But I thought the Bar Council has a fair amount of money. So depending upon the financial capability of a junior who is entering the profession today, they can certainly provide a stipend which might meet the immediate needs. For instance, I would always notice that some lawyers might have difficulty even to purchase the black suit and the gown that he needs to enter the court. There are also lawyers who start the practice, but because the fee, which is not too high, to join the Bar Association, say Guwahati High Court Bar Association, or the Supreme Court Bar Association. They can't afford. So they don't take the membership, and they take the membership 6 or 7 years down the line. So you have these examples, and you don't have to give it to somebody who comes from an affluent background, but somebody who is actually in need of that aid and can be a transformative change for that particular person. I think this can be done. I mean, there is enough money available. And even if you ask a pool to be created by contribution from the senior, successful, well-earning lawyers, I'm sure such a thing would come about. Only thing, somebody has to sort of take the initiative.
And so the second aspect of mental health, because this is not just within the litigation that the young lawyers are facing, but also in the corporate fields. Very often, the work conditions would be such, or they wouldn't be such a very conducive environment that freshers would just leave legal profession in itself. You know, they would be so traumatized in a way of their experiences in the growing stages that they would develop a sense of bitterness. So, what is your take on this, on the need for enhancing mental health well-being within the legal profession?
Now, mental health is a very serious concern, I would think, particularly when we are looking into law as a global world. Now, we have, say, in a large corporate law firm, you have young lawyers who are required to brief seniors. The senior might be located in London, might be located in New York, might be located in Australia with different times. So, a senior who would determine what time would be convenient for him or her will determine when the junior has to do the briefing. Very often, hard deadlines are there for certain goals to be made within the organization, and junior, we very colloquially we say burning the midnight oil, but very often the midnight oil gets burned until the next day dawns. So it is going well beyond the midnight oil. Now there's a tremendous pressure, and the pressure is the pressure to perform, meaning thereby if there are X, Y, Z in a particular firm, suppose X notices that Y is able to deliver her assigned task, let us say by a particular deadline, X is equally charged up to produce the same assigned task for the firm within the time. And in the process, you are losing your mental equilibrium because you have a deadline in front. You may have so many issues. Your laptop may have broken down. You may have issues. Your Wi-Fi is not functioning. I'm talking about today's lawyers. So suppose the Wi-Fi goes off. At midnight, the person has to find out a way to connect. Or your laptop has fallen off. I've had recently an instances of a law clerk in my office. In the anxiety to do the last minute job, and I had a judgment to deliver, she was working desperately on that. The final touches, her laptop fell off. I said, oh my God, the judgment is scheduled to be delivered today. What is going to happen? Because everything was corrected. The only thing I added is that last line should be added. And while it was being done, then my secretary came and said that, no, sir, we have a backup copy, and that's how. So therefore, what the question here is that we need to have the mental pressure, the mental health of a young professional lawyer to be addressed. In my court, because I can talk about what I can possibly do, I would, particularly for young lawyers, I will not give them the intimidating environment in the court. Very often people say that I try to lighten the mood, but the lightening of the mood in a court was primarily targeted at the young lawyers. The seasoned lawyers are not concerned about whether the court environment is intimidating or the judge is being stern or stark. He or she is way beyond those kind of the difficulties in court, because he has seen through that all. But for the young lawyer, if you make the court environment a little light, she or he can produce the best, and by producing the best, she or he can possibly get relief for the client that she or he is representing, and also, if not relief for the client, at least get a good hearing and offer good assistance to the court. So it works for both the court and the lawyers.
So that's quite an interesting point you made. You said that how, even though you are a judge of your court, you would make sure that even the most fresher of the lot coming and presenting before you should be made to feel comfortable. So what is your take on the need to have a harmony between colleagues, between the immediate junior and the immediate senior? Because very often we'll see that in the whole work pressure and the pressure of meeting deadlines and other things that are going on in the office, there's a certain competitive edge that comes within colleagues. And we are already in a very competitive profession of law. So what is the best way to deal in such scenarios and ensure that there is more harmony than negative competition?
I think it was Fali Nariman who said that for a lawyer, you spend a great part of your day in the company of your colleagues rather than in the company of your spouse. So therefore, it is important, although you are in an adversarial litigation, you are opposing each other, but the opposition should last or linger only while the case is being argued and debated in the court. But beyond the court, you must have a friendly relationship with your colleagues who you are meeting them every day, and perhaps you are in their company for longer time than you are in the company of your spouse. So this is said by no less than Fali Nariman, and I would perhaps echo what he said and say that we don't need to carry our court battles into our personal relationship. Personal relationship should remain pleasant at all times. Why is the need for breaking our head over an issue that we had sort of argued in the court? We don't need to carry that out of the court. Let the judge suffer with whatever arguments you have made, and you don't have to sort of take it to your professional colleagues.
So now, talking about the increasing number of women that we see in the profession, and also that one of your own daughters is in the legal profession, you may have closely seen the struggles and the obstacles that women are facing in the profession. So what, according to you, can help enhance the situation of women within the profession? What would be the more practical ways of doing that? You did mention of hybrid hearing in your previous interviews, where you said that the increase of hybrid hearings in the courtrooms, be it High Court or the Supreme Court and some district courts also, has helped women multitask, take care of their chores while also pursuing law. That being said, what other factors do you think can facilitate?
Well, hybrid mode is certainly a good way to sort of take it forward. And you'd mentioned one of my daughter, our elder daughter Kajri, she's qualified in sports law. But right now she's working in her niche areas, but then you go through the usual law firms. So there I saw her myself having to brief senior or prepare the notes for the senior at unearthly hours, because say I don't find her on the breakfast table, and then I make inquiries later on and I find that she was into briefing or preparing notes late at night and burning midnight oils and beyond. So I saw from the experience of my own daughter Kajri, and that is something which we can encourage the young women lawyers by firstly providing them the right environment for bringing out their best. When we talk about the right environment, they need not be also additionally be confronted with situation of maybe leaving a young child behind unattended at home and having to attend to the work in court. They may also have the issue of commuting long distance, which for a woman is a little more cumbersome. They may also have issues about being the first caregiver for the elders in her family. These are very commonly understood. It is expected very often that it is the women in the house who will be the first caregiver for the elderly, and not the men. Of course, I can say that as far as I was concerned, during the last 4 months of my father's, eventually he passed away, I constantly was by his bedside, and I consider it to be a great blessing that I had this opportunity. But very often women are at the forefront of multitasking, as you have said, child, husband, in-laws, sick relatives, so many aspects. But ultimately, if you have a sensitive boss, and that's the first thing, and next thing is a sensitive system. Now, how to make a system sensitive? I would perhaps like to speak of what the former Chief Justice D.Y. Chandrachud had initiated the process of facilitating virtual hearing. Of course, COVID assisted all that, but I am sure that must have empowered hundreds and thousands of women lawyers to make their presence in court. Also, the recent recognition of large number of women lawyers as senior counsel, I think that would also give a boost to their working capabilities. And also the women lawyers having a voice to speak. If they are being exploited, if they are being subjected to exploitation, they know that they can protest and their protest will be heard. It is not that they have to cry in darkness. I don't think that era of darkness is present anymore. There could be one or two instances, but by and large, we are having a society which is believing in freedom, particularly of the women lawyers.
So you've mentioned about your fondness for books, and you've had a very enriching career as a lawyer and as a judge. Do you plan on writing a book anytime soon, or that's not on the cards?
Not on the cards, but that it will not happen, I can't say. Because very often my friends say that perhaps there is a book in you, but when that book will come, or if it at all will come, that we don't know, that the future will say. But one thing I can say, earlier when letter writing was a common thing that people used to do, I was mostly educated in hostel. So I used to write letters, and my mom, dad, or any other relative, they used to be happy about receiving a letter from me, and they will later on say that, oh, it was such a nicely written letter. But after I became a lawyer, they said that the standard of letters have become horrible. A lot of legalese are coming in. And so I think I have to first and foremost, get rid of these legalese in the expression that I commonly use. So I'll have to sort of take it out of my system, and only then an interesting book could be there, but not otherwise.
So as we reach the end of our interview, we all know how dearly you love theatre. And in one of your interviews, you also said that you've listed down a bunch of plays that you are looking forward to watch in the ongoing National Drama School's Rang Mahotsav Festival. So any top 5 play recommendations that you would like to give to our viewers before we end this segment?
You see, the recommendations can be many, but you may not be knowing or familiar with a particular work. So one strong way of going about it is by looking at the director. Who is the director of the play? For instance, yesterday evening, I and my wife Chandana, we went and saw in Kamani Auditorium the Ibsen's classic Enemy of the People, Ajat Shatru. So that is directed by K.K. Raina and Ila Arun. Ila Arun is also, they are all products of the National School of Drama. Similarly, try and identify the director I have a few plays which I have listed out, not only for myself but also for my theatre-loving friends. I can produce that list, but that would be being unfair to the others whom I may not have identified. So I may mention the play that I saw yesterday, and I have few plays listed out in the next few days.
And the courtroom dramas that you've already suggested
Yes.
us.
There is a play, Hamlet is on. Then there is a play which is on Shakespeare's, Midnight Dreams. But it's, I think the title is Middle Class Shakespeare's Dreams. They have twisted the title a bit. So there are several. I'm sure there's a play called Tamasha. I think it's from Kerala, Malayali. And then there's a play, I think written by Habib Tanvir. Then there's a play written by Badal Sirkar. So there are very, very interesting options. And I think you will not be disappointed by seeing any of them, because if you go there, you will find that these are all shortlisted plays. So I'm sure all of them would be of very high quality.
Thank you so much, sir, for having us and openly discussing about all these important issues. Thank you so much, sir.
Yeah, I enjoyed the conversation. I thank Livelaw for having me for join this conversation. Thank you.
Thank you, dear viewers. I hope this segment did serve as a food for thought for a few at least. Do hit like, comment, subscribe, share our YouTube channel to get such valuable updates. Thank you.